Thank you for the introduction. Esteemed professors, researchers, students, guests, dear colleagues, I'd like to first of all express my gratitude for having me here. Thank you for the opportunity to participate and to contribute to this project, so not only conference but the book as well. I wrote a chapter about Serbian perspective of child-friendly justice. I have to say that I'm not a family lawyer, family professor. I teach civil procedure, but as we all know, there's not just law in books, there's law in action, and not in most cases, in majority of cases, the children's rights and parents' rights, etc., are enforced in civil procedure. And it's always a difficult task to give a national perspective or national report on one subject or one topic, especially when it comes to the child-friendly justice, because there's a danger to go into the details of the national law and so on. So I could only give you a brief overview, and I will focus my presentation on child's right to be heard, so how Article 12 of CRC, Convention on the Rights of the Child, is implemented in Serbian law, and I'll address some issues of hearing the child, so not just in a way of expressing his own opinion, but as witness, for example, or already to say that we are lacking provisions, special provisions for a hearing procedure of minor witnesses, which I find that it's unsatisfying. So I'll firstly make some structural remarks about child-friendly justice, try to say something about the notion itself. Then I move on to the core of the presentation. So, sorry, before that, of course, I will briefly address the framework of Serbian legal system in reference to the child-friendly justice. Then I'll move on to right to be heard or implementation of Article 12 of CRC in Serbian legal order, and I will then close the presentation with some remarks about hearing the child. So what does it really mean, child-friendly justice? What this friendly stands for? At the beginning, I should say that from procedural perspective, it's not the first time that adjective friendly is used in the legal discourse or procedural legal discourse. For example, there is, I think that's a proper translation from the German, there is one rule of interpretation of procedural statutes, so-called substantive law-friendly interpretation. So we have friendly. Materielle rechtsfreundliche Auslegung. So we know, we have already that adjective friendly. On the other hand, we have arbitration-friendly jurisdictions. But what does it mean when we say child-friendly justice? Is that friendly, is the focus on child itself or the parents? One can imagine child-friendly justice that judges can bring their children to the courtrooms. No, its focus is on children. I'd say, I could attempt to define it. Child-friendly justice should be regarded as sum of laws, principles, procedures, and practices. I think practices are equally important as laws of within justice systems that are designed to respect, protect, and fulfill the rights and needs of the children. More specific, that is justice system that is accessible, protective, age-appropriate, and inclusive or participatory. And of course, the that justice system is based on 4 pillars of CRC, so consideration of best interest of child, of course, right to life and development, non-discrimination, and of course, participation. And the core element of that principle is right to be heard. Because I'm a civil procedure teacher, professor, I have to make some remarks from my dogmatic perspective. Child-friendly justice could be described as paradigm of materialization of procedural law. By materialization of procedural law is regarded a creation of special proceedings that are based on the principles, guidelines, major rules that are quite different from those in classical proceedings. So, for example, and good example is family procedural law. We have the active judge, we have the judge who is investigating the facts, he has the initiative, and so on. So, and why materialization? Because the values or the valuation goals set in substantive law are transposed into procedural law. After all, procedure has only one function, and that is to serve to the substantial law. So, when we speak about participation rights of children in Serbia, of course we should start with the constitution, but there is no explicit mention of participation's rights in Serbian constitution. It's rather said that children enjoy human rights according to their age and mental maturity. But on the other hand, and bearing in mind that CRC was ratified back in 1990, and that's my mistake, in my chapter it stated 1991, I don't know why. It is 1990, but it doesn't matter. The CRC is part of Serbian legal system and was before. Why I'm saying that? According to the Constitution, human rights guaranteed by general accepted principles of international law and those confirmed by international treaties are directly applicable and guaranteed through the Constitution. And bearing in mind that CRC is ratified, we could say that Article 12 could be directly applicable. But it was not until enactment of Family Act back in 2005 that statutory law really established preconditions for proper functioning of the system. It was Family Act of 2005 that promoted not only right to be heard, but best interest of child as a superior legal principle. And this act was aimed to fulfill all international duties of Serbia stemming from international conventions, most importantly CRC. Of course, there are other laws, other statutes, such as law on juvenile criminal offenders and criminal legal protection of juveniles, in short version, law on juveniles, and of course procedural codes that sporadically address some issues. Now we'll move on, and I have to be quick, to the right to be heard. The concept, we have general classic concept right to be heard, so that's a basic human right in every proceedings to have the opportunity to present its own case before the decision is made, decision that affects rights and obligation of that person. That is part of fair trial principle, right, or due process, but it also stems from principle of untouchableness of human dignity, because if one individual is deprived of that right, he or she is no longer subject of the proceedings, rather object, and that should be against the human dignity. And when it comes to child's right to be heard, there are some parallels, of course, because as it's founded in the Article 12, every child that is capable of forming his or her opinion will have right to express it freely. And such concept is based on the premise that child is a subject of rights which have an influence on his or her life, that his child's opinion should be taken into consideration when deciding about or on the rights or duties or interests of the child. And the holder of right is every child that is capable of forming her or his views. So there is no age threshold. And we have heard yesterday in numerous occasions that voices of children are important, but also that a voice is not enough. Right to be heard, and I think that's a proper term or notion, not the right to participate or right to express opinion. Right to be heard is a proper term, because the focus is not only to opportunity to present his case or the opinion, but that opinion should be really considered, so the child is heard. Of course, there is no obligation for the court, for instance, as a deciding body to follow the opinion of the child, but it should play some role according to the age of the child and maturity. So how this fundamental right is implemented in Serbian law? I'd say that Article 65 of Family Act is Magna Carta, as in Article 65 is defined who has the right to express his or her opinion and what is the impact of the opinion. But it's not easy as it looks at the first glance, because we have some controversies about age threshold. Namely, according to Article 65, paragraph 1, child capable of forming his or her view has the right to express it freely. But according to paragraph 4 of the same article, child which has reached the age of 10 can freely and directly express his or her opinion in any court or administrative proceeding. So we have some mention of age threshold. And always, as always, we have two schools of thought. One approach which suggests that paragraph 1 is lex generalis and paragraph 4 is lex specialis. So these two provisions are in collision, and in result there is age threshold vis-à-vis court and administrative proceedings. According to another approach, I would say it's definitely prevailing view, or herrschende Meinung. I don't know how to translate it in English, but it's good. Prevailing is not so strong, but it's important to say that the Supreme Instance, Supreme Court of Serbia back then, now it's just Supreme Court, also supported this view. So in result, there is no age threshold, and this problematic provision, Article 65, paragraph 4, is qualified as a provision that stipulates rebuttable legal presumption that 10-year-old child is capable of forming his or her opinion, but the younger children are also not excluded from that right. As Supreme Court stated, right of the child to freely express opinion is limited by his capability of forming own opinion, and accordingly no age threshold is for exercising such right is prescribed by law. So, to wrap it up then, the capability of forming the opinion is the only condition or prerequisite for the right to exercise the right to be heard. But then it is a question of the notion of this, one could say, legal standard or undefined notion. Sadly, there is no clear case law about this topic. So what that it really means to be capable of forming the opinion. Sadly, Serbian courts are of the opinion that their task is not to define undefined legal notions, to provide guidelines. On the contrast, in the legal theory, there is suggestion to adopt a broader approach in line with General Comment number 12. So that should be competence, capability of forming opinion is competence to develop and articulate one's will, regardless of whether that will is free, reasonable, or meaningful. So even a child which is 5 years old could be holder of this right. When it comes to assessment of the capability of forming the opinion, according to case law, it should be left to the experts, to the guardian authority, because typically courts are not qualified, that's their perspective, qualified to assess capability of forming the opinion. And at the last, impact of the child's opinion, it is expressly provided that there is a duty to give due weight in accordance with age and maturity of the child, and it's more or less in every decision of the Supreme Court, it is stressed out that assessment of the impact of the child's opinion should be assessed in light of consideration of the child's best interest. Child's best interest is qualified in Serbian case law as the supreme principle. I think I have come to the end, so I'll have to wrap it out. If you are interested, I invite you to read more in my paper. I'd say that sadly, as always, there is discrepancy between statute law and law in action. Maybe that's a problem of rule of law, Rechtsstaat. But I think our research should be both focus on text, but also on practice. After all, we need results. As you mentioned before, yesterday you said Article 12 demands structures and demands action. Thank you for your attention.